in a couple of minutes. So again, my sincere apologies. The speakers, I think certainly one is on, which in fact both speakers are online, so we will be starting in just a few minutes. Again, my apologies. Right, ladies and gentlemen, we're going to start. Again, our sincere apologies for starting half an hour late than what we should have been. We have two speakers this evening, Iver Orstadvik, I apologize if I'm pronouncing that incorrectly, and Sheriff Susan Craig. Before they start, can I just remind you that as this is the last of the 4 lectures, later on this evening, we're going to be changing the teams about. So by tomorrow morning, you will know whether you are for or against the motion. Some schools will find that they've had some additional students added to them where their numbers were short. Would you please reach out to those students to make sure that you're all knowing what you're going to be doing in terms of the debates. The debates will be taking place in 2 weeks' time. Will take place in 2 weeks' time, at which point you will find out whether or not, when your trial or debate is actually going to take place. For those of you who this is the first debate, the way the system for winners is based on points. You can go online to mockcourt/debate to to see who the judges are going to be. And at the end of it all is when you find out what your ranking is in terms of individual speakers and your overall score. At the end of it all, everybody does get a certificate. We will post more details up on the forum, so please, I would ask that you check the forum for any updates, but log in probably tomorrow lunchtime, and you'll find out when your debate is actually going to take place. And fingers crossed we have no more IT problems. Now let's look at the two speakers this evening. They will each be making their own presentation before they then will debate the matter between themselves for about 10 minutes, and thereafter invite questions from you all. Iver Orstadvik was a previous lecturer for the Department of Philosophy at University of Bergen. He is now a senior advisor to the Rafto Foundation for Human Rights. Susan Craig is a sheriff, that's a Scottish term for a judge here in Scotland, and is also the Deputy Director of the Judicial Institute for Scotland. So if I could invite Iver, I think first, Mrs. Craig to come first to speak to you, and she'll be followed then by Iver, and thereafter they'll have a debate amongst themselves before calling for you to speak. So I'll go quiet and allow this to carry on.
Well, thank you, and good afternoon to everyone. I'm sorry that we're starting a bit late, but we all know that these things can happen. I am today going to be proposing the motion that judicial independence be maintained in Scotland. And of course, as you might imagine, I want to persuade you why you should agree with me. A number of the points I will make may already have been covered by other speakers that you have heard from, but I make no apologies for that, because hopefully it will reinforce the strength of the arguments that I'm going to be making. But before I do, let me tell you just a little bit about myself. As Gerald says, my name is Sheriff Susan Craig, and sheriff means judge. It doesn't mean that I've got a horse or a gun, and it's got nothing to do with the frightening enforcers you might have seen in the BBC TV programme called The Sheriffs Are Coming. The title sheriff is in fact a very old Scottish title, and there have been sheriffs for hundreds of years. I sit in the Sheriff Court here in Livingston, where I am just now, and I hear both criminal and civil cases about both public and private law issues. I can send people to jail for up to 5 years, although in some circumstances it can be up to 7 years, and there is no limit to the amount of money I can award in civil cases. I hear cases about children, such as adoption, care proceedings, that sort of thing, as well as cases brought by the state to look after old people who can no longer look after themselves. If you wanted to address me when I'm in court, you'd call me my lady, and when I'm not in court, you would just call me sheriff. Now, none of my family were lawyers. My dad was in fact a farmer, and my mum worked in shops. So I don't have my job because of any connections. I have my job because I was selected for it, but only after a competitive, competence-based interview process run by an independent board made up of both lawyers and non-lawyers, and the majority of them are in fact non-lawyers. Now, some of you, certainly those in Scotland, might right now be in the middle of your Nat 5 or Hires assessment. And the appointment process is a little bit like that, because I had to provide objective evidence that I had the skills, experience and ability to be a judge, and I had to sit the equivalent of an exam and then an interview. But because I wasn't appointed by the government or politicians, I don't depend on them for my job. And I'm telling you all of this because it sets the scene for why I'm so passionate about the topic that judicial independence be maintained in Scotland. However, that rather begs the question, what does judicial independence mean? Well, in its most basic sense, independence means the freedom to make decisions without being governed or controlled by others. And who are the others that might want to govern or control judges? Well, there are three branches of government. There's the legislature, that's Parliament, either Westminster or Holyrood, because we're in Scotland, and it's made up of several political parties with a range of views and which makes and passes the law. There's also the executive, that's the government of the day, which is led by the majority party in the legislature or a coalition of parties if there's no absolute majority. And then there's the judiciary, people like me. Judges are separate from and not directly accountable to either the legislature or the executive. And that separation of powers is important because it means that, firstly, cases are decided by judges on the basis of the evidence and the law, not on the basis of influence or interests of government or parliament. In other words, it's the right to a fair trial based on the evidence in the case. The separation of powers also means that the public can have confidence that the outcomes of court cases are reasonably foreseeable and predictable. In other words, if they end up in court, they can have a degree of certainty, and that promotes respect for the outcomes. And finally, the separation of powers means that judges provide a check on the power of the legislature or the government where that is necessary. Now, as you might imagine, this isn't some kind of unique Scottish arrangement. The Council of Europe has said only an independent and impartial judiciary can provide the basis for the fair and just resolution of legal disputes, particularly those between the individuals and the state. And many of you will be familiar with the European Convention on Human Rights and Article 6, which requires that in the determination of his civil rights and obligations, or any criminal charges against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. So this afternoon, I'd like to look at these three elements. That's the impartiality of decisions and the right to a fair trial, predictability and respect for court decisions, and the check and balance function performed by courts in a bit more detail. So on the first point, judicial independence in the sense of being independent from influence or pressure is vital to ensure impartial decisions and decision making. And impartial in this context means not supporting any of the sides involved in an argument. So for a trial to be fair, it must be heard by an independent and impartial court, because it's that independence and that impartiality that guarantees the equality of parties before the court. Now, I always think it's helpful to try and imagine these principles in a real-world example. Suppose you'd been injured when you were knocked off your bike by a car that was being driven down the wrong side of the road. Now, you know you're in the right and that the driver is at fault, so you raise a case in the Sheriff Court asking for money to compensate you for those injuries. Now, the independence of the judiciary means you can be confident that the judge will listen to all the evidence presented and base their decision on the facts established by that evidence and what the law says should happen based on those facts. But if the judiciary wasn't impartial or independent, there'd be a risk that the judge might find against you if it turned out he was a friend of the car driver, and no matter how badly the car was being driven, he found against you. Or maybe the judge would find against you because the judge believes the government of the day was anti-cycling and doesn't want to risk losing their job if they made a pro-cycling decision. Those sorts of decisions would be biased or tainted. Now, because judicial independence is a cornerstone of a functioning democracy, I would argue, in Scotland it is protected by it being embedded into our system. First of all, there's a specific statutory duty on the First Minister, that's our Prime Minister in Scotland, the Lord Advocate who leads the prosecution service, the Scottish ministers, that's the government, and members of the Scottish Parliament to uphold the continued independence of the judiciary. So what that means is that in law, the government must not seek to influence any particular judicial decision through any form of special access to the judiciary. And the second way, or a second way that it's embedded in our system, is that judges that are appointed to the Scottish courts take two oaths. The first is an oath of allegiance to the Queen, to the particular sovereign, and the second is a judicial oath. Judges swear that they will do right to all manner of people after the laws and usages of this realm without fear or favour, affection or ill will. So the judges that are taking those oaths are promising, firstly, exclusively to follow the law. In other words, judges don't get to pick and choose which law to apply based on their personal views. And they have to make decisions without regard to whether that decision is popular or not. And the second thing judges are promising when they take that oath is to apply the law without fear of punishment or removal from office for making a decision that's disliked by another branch of government. So I thought it might be helpful if we looked at the first of those promises, that a judge can't pick and choose which law they apply depending on their own personal views or pressures. In the United Kingdom, it is the law that same-sex partners can adopt children. Now, recently, a judge in England refused to allow a same-sex couple to adopt because his particular religious belief was that only heterosexual couples should raise children. Now, he was sacked as a judge, and he appealed and argued that his removal from office amounted to religious discrimination. But the Court of Appeal rejected that and found that by refusing to apply the law because of his personal view that the law was wrong, the judge had fundamentally breached his duty as a judge. Now, of course, everyone is entitled to freedom of thought, and there might be some of you watching today who might share the judge's view, but that isn't the point. The judge was entitled to hold a personal view that the law was wrong. What he wasn't entitled to do is just ignore it and impose his own view. So I pose the question of you, would you be concerned if you knew judges applied the law based on their personal views rather than on the law? And I hope you would be. Now, that judge wasn't sacked by the government, and he wasn't sacked because he made a decision that politicians didn't like. Instead, he was removed from office after an independent and impartial tribunal found he wasn't doing a fundamental part of his job. Now, we have the same process in Scotland. So a judge who decides a case which is disliked by politicians can't be ordered to be sacked by the politicians and can only be removed if found unfit for office by an independent tribunal. Now, you might be thinking to yourself, why is it important that politicians don't get to pick judges? After all, politicians are voted for by the people and have a democratic mandate for the laws that they make. So why shouldn't they get to pick judges that won't overturn those laws in their judgments? Now, many of you will know that the system for appointing judges is very different in the United States. Supreme Court justices and some other court judges are nominated by the president of the day and confirmed by the Senate. In a number of states, state court judges are appointed by a governor at his or her own discretion without any input from a judicial appointments commission. In 14 of the states of the United States, judges of major trial courts are elected in partisan elections, meaning that they can be chosen according to the political party to which they belong. And those judges can be re-elected or indeed may lose their position following an election, presumably if the electorate aren't happy with their decisions. Now, my opponent, Mr. Orstadvik, may tell you that given that this is the biggest democracy in the world and it appoints its judges, what could be wrong with this approach? Well, what I would say about that is that in such a system, there is no guarantee that the best people become the judges. They are elected or appointed because of their political beliefs or because they're perceived to be easily swayed in a particular direction. You just have to think about Donald Trump. In his single term as president, he appointed 54 federal appellate judges, and that was only one short of the 55 that President Obama appointed in his entire 8-year term. And the result of that was that Donald Trump switched the political composition of several appeal courts from what were a majority of Democratic appointees to a majority of Republican appointees. He also had a major influence on the United States highest court by appointing 3 Supreme Court justices. Well, Mr. Orstadvik may also tell you that by hand-picking judges, presidents can do wonders for improving diversity amongst judges. On the 31st of March this year, President Biden unveiled 11 nominees for various courts, and all but one of them were women or from ethnic minorities. Now, that's excellent that the president chose nominees to improve diversity, but there's no guarantee in that sort of system that any past or future president would do the same. And bear in mind that President Trump appointed a smaller percentage of non-white federal judges than any other recent president. So you can see from this that while there is some attraction superficially to the idea of politicians appointing judges, it all depends on who is in power and whether they prioritize the inclusion of ethnic minority judges. You can also look rather closer to home for why political interference in the appointment of judges is a very troubling situation. The Constitutional Tribunal in Poland, for example, is one of significant concern, and the government is behind the disciplining of a Supreme Court judge who spoke out in favor of the rule of law. So politicians are interfering in a substantial way in the judicial appointments in Poland. Now, in Scotland, the Judicial Appointments Board has a statutory duty to have regard to the need to encourage diversity in those it recommends for appointment to the judicial office. So that duty, statutory duty, plus the independence of the system means that judges are not appointed, whether they're women or ethnic minorities or otherwise, to appease the public and win votes, but instead on merit and adjudicated by an independent panel. Now, you might think, if a judge was appointed by a politician based on the judge's political view, what happens if the politician changes their stance? Now, for example, our current UK Prime Minister was previously pro-EU, but then became to favour the exiting of the EU. Now, politicians are absolutely permitted to change their political allegiances, and I don't mean any criticism at all of that change. But if we have a system of political appointment, what happens to a judge appointed for their view if there's a change in political direction? I'm just posing that as a question for you to think about. So with that hanging there, I want to move on to my second point, which is that judicial independence is vital to achieve predictability and respect for judicial decisions. If judges were influenced by politicians or their own personal interests, decisions could be based on who has access to the judge, or which party was elected to government, or which companies, for example, a judge holds shares in. And that is not desirable, not a desirable state of affairs for two reasons. Firstly, it wouldn't be possible to predict the outcome of any court case. Instead, independence allows society an expectation of potential outcomes. It's also not desirable because it's unlikely that judicial decisions would be respected if the public and lawyers knew those decisions could have been biased. As the Council of Europe explains, it is of primordial importance that judicial independence and impartiality exists in fact and is secured by law, and that public confidence in the judiciary, where it has been lost, is restored and maintained. So why do you need to be able to predict the outcome of a case? Think about it like this. Most of you will have purchased clothes online. The point where you click to pay for the clothes, you have entered into a contract with the retailer. Now, imagine the clothes don't turn up or they were damaged. You would want the company either to send you a replacement or refund your money. But if a company refused, you might think about taking them to court. But if you couldn't be sure that the judge that would hear your case would decide it fairly and according to the law, that might make you less confident about buying clothes in the future, wouldn't it? If, for example, you had to worry whether the judge had shares in ASOS or was being influenced by politicians who wanted to attract a large retailer to their area, you might be a lot more nervous. And if consumers don't have confidence to enter into contracts, that would have a serious impact on the economy. So moving on to the third point, the importance of the check and balance function that an independent judiciary provides. The independent judiciary holds the legislative and executive branches of government to account. That is essential, I say, in a functioning democracy. If the other branches of government overstep their powers, it is the role of the court to point that out. Now, there's a process known as judicial review, which allows people to challenge decisions taken by, for example, a local authority or a government department if they believe that they are the wrong decision. Now, this comes up quite frequently in immigration cases, where a person challenges a decision of the Home Office, for example, to refuse asylum applications, or where removal has been ordered. Judicial review process allows the court to decide whether those decisions made by a government department were correctly, in the sense of lawfully, made. Now, you might hear later that there's a view that the judiciary interferes too much with acts of government. It's not for the judges to second guess what politicians have done, for example. But the reality is this: sometimes governments do go further than they are entitled to. And there has to be a system of supervising that, because without it, governments could take decisions that were unlawful and take them with impunity. Many of you will remember that in 2019, the United Kingdom Supreme Court decided that the UK government didn't have the power to cancel Parliament for 5 weeks. The Supreme Court said the government had gone too far. Now, if the court didn't have the power to decide that, then the government could have acted unlawfully with no check on that action. An example a little closer to home, more recently in the Court of Session here in Edinburgh, was asked to consider whether the Scottish Government's coronavirus regulations, which had forced the closure of places of worship in January this year, were lawful. The court was asked if the government had the power to restrict worship and whether that closure infringed human rights. Now, the Court of Session found that it did infringe on those rights, and the churches were opened again just days later. So I suggest this shows the importance of having an independent check or oversight on the powers of government. Because without that mechanism, citizens such as us are unable to challenge potential human rights breaches, which would in turn mean there's no effective way to seek compensation or to challenge potentially unlawful acts of our government. So I'm coming towards the end now, and I hope I haven't overrun my time too much. But this afternoon, I hope I have shown you that judicial independence is vital in a democratic society such as ours here in Scotland. It's necessary for the making of decisions based on law and the facts in the case, rather than personal beliefs or bias. It's necessary to create respect for judicial decisions because they're more likely to be predictable if based upon the law. And it's necessary because judicial independence allows the courts to carry out the crucial role of checking the government's power. So finally, I encourage you to agree that the judiciary should be independent of government. Thank you. Gerald, back to you.
Thank you very much, Susan. Very much appreciated. Iver, would you like to start yours? Now, I should point out to everybody.
Hello?
Oh, sorry, I don't speak at all. I didn't push the button. I do apologize. So, Iver is going to speak now. The views. The microphone keeps muting itself. I do apologize. The views that Iver giving are not necessarily his own. Iver, I pass over to you. Thank you very much.
Thank you so much. Good afternoon, everybody. It's a great pleasure to be invited. I was asked to take part in this exercise by my friend and judge in Gdańsk, Dorota Sabledowska, and it's really nice to be able to be of some use to her. Secondly, it's a pleasure because we are at least virtually in Edinburgh, a town I like very much and where I even have forefathers in the Turnbull clan. Well, so my name as presented is Iver Orstadvik. I work for the Rato Foundation for Human Rights in Bergen, Norway. I'm a philosopher by education, an activist by occupation, so I do not work in courts or very close to the courts, but with politics shaping the institutional framework of courts. So I'm looking at this, I guess, from an external point of view as compared to Sheriff Craig. Now, I am commissioned to argue against the statement that the judiciary should be independent. It has not been so easy as I imagined, but I'll give it a try. I do presume that the conventionally held position, at least in Scotland and in Norway, is the opposite, namely that the judiciary should be independent. I will argue that this conventional position is in the end misguided, that we will be better off recognizing that the judiciary can never be fully independent, and that we ought to strive for a proper form of dependence rather than a delusive independence, which hides the real power exercised behind judges or by judges. Proper form of dependence, I will argue, is secured by subjecting the judiciary to the legislative, in my case, the Storting, in your case, Holyrood or Westminster or whatever parliament may hold the power to legislate where you hold the citizenship. All power in the halls of parliament, as was the catchword for the liberal movement establishing parliamentarism in Norway in 1884. But let me start with a few words about independence of the courts should or could mean. I believe there's no disagreement that the authority of judges and crucial aspects of how they are to carry out their work should be circumscribed by law. The contest's claim is whether the execution of judicial work can, and under certain circumstances, should be instructed from or overruled by, or otherwise subordinated to an external authority. And I'll try to make an argument which leads to this conclusion. And the outline could be roughly as follows. Under normal circumstances, the content of law is determined by judges and the power of law by the executive, and not by legislators. Now, a completely independent application of law by judges contains unavoidably arbitrary elements, even under normal circumstances. And it may be fundamentally inadequate under extraordinary circumstances. Power supporting the law and allowing it or not allowing it, as circumstances may be, to be effective becomes apparent when a state of exception is declared because of events in the world, it might be, or because a systemic failure of the legal system itself. Now, in the end, the application of law must rest in the hands of some external authority who can hold the courts accountable for its practice and judges for their actions. And this external authority can either be authoritarian or it can be democratic. And given a preference for democracy over other forms of government, power should ultimately be placed in the hands of democratically elected persons, that is, in the legislative in parliament. So, to the first point, the content of power of law is determined through its application by judges, and it contains unavoidably arbitrary elements. The law is conventionally understood as a collection of norms prescribing actions which are allowed, required, or prohibited under certain circumstances. And the laws are given by the legislature to be applied by the judiciary and executed by government official of some kind. Now, the separation of legislation and adjudication is usually a pragmatically sensible division of labor, as Sheriff Craig has explained. It is, if not necessary, so at least often desirable to maintain such a separation in order to secure that laws are not made for the exclusive benefit of those who apply it, or vice versa, to prevent that those who apply the law cannot invent laws to fit the rulings they prefer. Now, in a state ruled by law, legislation and adjudication should first and foremost secure that law is not made or applied in an arbitrary manner. Um, um, and there are many dimensions of arbitrariness which one might want to consider. So the World Justice Project, for example, lists the rule of law measures of constraints on government powers, absence of corruption, open government, protection of fundamental rights, provision of order and security, effective regulatory enforcement, effective civil justice, and effective criminal justice. These measures of rule of law all address desirable ends to pursue for a legal order. But the implicit indication that they can be fully achieved and is at least commendably approximated in states rewarded by the highest honor of a dark green coloring on the map of the project betray one fundamental fact. Arbitrariness cannot be removed from the legal system. I do note, by the way, with some satisfaction that the two top scoring states in the World Justice Project are Denmark and Norway, the ancestral home of the Vikings ravaging England and Scotland. The times they are changing. Now, the most effective regulation of human behavior is certainly in most circumstances the ordinary moral and social norms, widely understood as any norm which is adhered to by conviction or habit, established through ordinary, non-coercive interplay between individuals in a community, everyone watching over themselves and those nearby. Now, such norms direct action away from ends we consider unjust or bad, and towards ends which we conceive as good and just, and indicate what means should or should not be used to avoid the former and secure the latter. But norms make sense only when we know that the good and just will not always be preferred over the unjust and bad. We have laws against murder, theft, and fraud because we know that murder, theft, and fraud does in fact occur, and often enough to be considered a problem. Now, moral and social norms often do not effectively regulate behavior on their own. It is essential that law adds incentives for lawful behavior when morality does not suffice by attaching punishment which effectively discourage violation of the law. Law is therefore essentially different from morality, which presupposes that we are free to act or not act as recommended. Under law, we are not free, but expected to act or not act as commanded. The role of law is to intervene precisely when moral regulation of interaction does not work properly, and therefore it cannot be presumed to work as moral regulation does. Law perhaps works only along the fringes of failing social and moral norms, but it is meant to come down hard. So rulings in a court of law are commands, not advice, and they presuppose the existence and functionality of an institutional apparatus securing that the rulings are obeyed. The distinctive power of law is exercised when the apparatus which translates rulings into coercive action, for example, in the form of fines or arrest or imprisonment or other interventions in the life or business of a person or organization. And this apparatus comes into operation only when rulings are made by judges in court, or secondarily, when other actors possessing decision-making power predict that certain rulings would be made if the question at hand was presented to a court. And so they adapt to this expected ruling. Now, if there is no such apparatus, or if it does not work properly, the law does not work properly. Therefore, the meaning of law is exclusively decided in the courts, and adjudication depends not so much on whether it corresponds with the intentions of the legislator as it does on whether rulings have the intended effect as means of effectively regulating behavior. The legislator suggests what ought to be done, the judge decides what is to be done, and the executive does it, hopefully. Now, the law covers broad categories of cases such as murder, theft, fraud, etc. But instances of murder, theft, etc., of course, cannot be deduced from these categories. The law is applied by identifying particular cases which are presented to the court, events that take place in society under more or less bewildering circumstances, and which are then subsumed under the categories of the law. And this work must be done by specific persons in specific circumstances and depends on their ability to exercise good judgment, both when they describe cases and when they interpret the law as either covering or not covering the case at hand. And the circumstances described by Sheriff Craig is ones where this all works and everybody's happy. And then allowing judges to be independent has only an upside and not a downside. Okay, well, I should not now make the impression that I think that judges operate in an empty space, that they operate without support. Of course, similar cases will normally have been adjudicated before. Certain interpretations of the law will be recognized as proper and others not. Judges are more or less tightly bound by precedent. But precedents are also specific acts made by specific individuals in specific circumstances. And the environment of the law is constantly changing. New interpretations emerge as more convincing as time passes, and new cases appear with characteristics that may or may not be considered to belong in the same category as cases which are partly similar, but also partly dissimilar. In some contexts, more or less fundamental shifts take place in the public understanding of what should be allowed or disallowed, changes which may be reflected in judicial practice without being subject to new legislation. In Norway, for example, as in many other Western countries, the law designating homosexuality as a crime long outlasted the general consensus in the public that it should not be considered a crime. And the prosecutors and judges simply quietly stopped processing such cases. And in other contexts, incompatible views compete for hegemony and laws strike uncomfortable compromises, leaving it to the judges to choose between the alternatives. An example could be the abortion law in Norway, where the right to free choice takes absolute precedence until the 12th week of the pregnancy. Then there's a 6-week twilight zone where requests for permission to have an abortion must be presented for a commission legally empowered to decide. And then from the 18th week and onwards, the right to life of the fetus takes absolute precedence, unless there's a medical emergency and danger for the mother's life. So, when laws are applied in court, several kinds of arbitrariness are introduced when observed from the point of view of the legislator. On the one hand, judges will in certain circumstances interpret the terms of the law in ways which do not align with the intentions of the legislator. On the other hand, judges may in certain circumstances identify cases to be sorted under categories of the law, which may not be the kind of cases which the legislative intends to be covered by that law. So there is an arbitrariness in adjudication which cannot be eliminated. And this arbitrariness also involves the use of force, which is an extension of the adjudication in court. And this is problematic. Arbitrariness is the antithesis to rule of law and should be avoided. The types of arbitrariness we have described here is related to the fact that the law must be applied by courts, and so they are not relating simply to the specific cases I used as example. In addition to the arbitrariness which is inherent in judicial activity under normal circumstances, we have the arbitrariness of states of exception. And we find ourselves now in a moderate version of such a state during the COVID pandemic. If we go along with the infamous legal philosopher Carl Schmitt, events such as these indicate where the sovereign power is really located in society. Sovereign power is located with the one who decides to declare a state of exception and who can do it. Any system of law will be adapted to a limited range of foreseeable circumstances and may be challenged by events which are dealt with by whatever authority can rise to the occasion. It might be a legislative, simply sidelining the laws already established by the courts, or it might be the executive initiating measures which exceeds its warrants, or it might be private citizens or organizations who improvise. Now, a combination of responses by the two former, the legislative and the executive, took place in many countries as the pandemic hit in March last year. Some states had laws which allowed for extensive emergency measures. Others went beyond the law and tinkered eventually measures and laws to become compatible. Now, we can let the judges have the final authority to decide what the law should be in such cases. Or we can hold the judges accountable to someone else, to an instance external to the court. This kind of external authority could be a charismatic leader, it could be a hegemonic party, it could be some traditional authoritative body, such as, for example, the elders of the church. But it may also, and in my view, it should preferably be the democratically elected legislative, that is the parliament, which in most or all states will be the body legitimately representing the broadest possible segment of the population expected to obey the law, and also expected to subject to it if they don't. So, in circumstances such as those which have developed in Poland, also mentioned by Sheriff Craig, the supremacy of parliament seems to be the only way to sort the legal disorder which has developed. Poland is now a battleground for competing and incompatible laws. Different judges dispute one another's credential to act as judges. Different courts contradict each other. And the hierarchy of the courts in general is in shambles. Arbitrary rule has devastated rule of law, and securing independence of judges can only be provided by a wholesale reform of the courts under the auspices of Parliament. And that's where I'll stop.
Iver, thank you very much. I know that Sheriff Craig will no doubt have some points to raise in rebuttal to what Iver has raised. But can I first of all thank you both for raising some interesting examples in terms of where the judiciary sit, and indeed some of the complications that they. So, Sheriff Craig, if I can pass back to you.
Yes, thank you, Gerald, and thank you, Iver. Can I just first of all say, yay for the Vikings, because I am half Viking. I'm half Danish, and the other half of my family now all live in Norway. So, in fact, I think of myself as properly Scandinavian. Anyway, I want to just think about what you said about the external bodies, such as perhaps the Council of Elders overseeing the decisions of court. Or that be the oversight be carried out by the Parliament, by the legislature. Now, what troubles me about that, apart from all sorts of obvious reasons, is that's fine when you lose. People will say, "Well, I want the bad decision overseen and looked at again." But what if you win? What about every case where there's a successful prosecution or a successful determination of the rights that the court has dealt with? Why would there be a need to have a run through of all of those points again in front of people who are not lawyers? Now, some people may say, of course, it's all a very tight legal community, but it should be a tight legal community. You want people who know and understand the law to adjudicate on the law. And with the greatest of respect to those in the legislature, they are not, in the main at least, practicing lawyers. You wouldn't, for example, want to have someone carrying out surgery on you because they had watched every episode of Casualty or ER and had an idea about what the right outcome would be on a diagnosis. You would want a properly trained surgeon. So why is it more right to have the legislature or the Council of Elders just ultimately decide what the decision is going to be than it is to have properly trained judges?
Am I supposed to respond? Wow, I wasn't quite prepared for this, but let me try. I guess the point I tried to defend is not one claiming that division of labor should be dissolved and the less competent meddle in legal affairs day and night. it is rather that whatever independent authority is given to the judges and the courts rests on something else. It rests on the power of other central institutions in society, the legislative and the executive, and also, the general circulation of opinions and norms which feed into the legislative process, and also affect how people look and evaluate the work of judges. And in the end, whether or not the courts perform in a satisfactory manner is up to society surrounding the system of the courts to decide. And that is an uncomfortable fact. So we can appeal for independence of courts, and we can argue that it would be, pragmatically sensible to make the system function smoothly and effectively and professionally. But if it doesn't, then it doesn't.
Okay, students, can I ask you now to start typing questions in the public chat area, either for Iver or Sheriff Craig. If you could just type in who you're directing your question to, or indeed if you're directing it to both of them. I'm hoping Iver and Sheriff Craig can actually see your public chat. You can? Okay. We're going to allow for about maybe 10, 15 minutes of questions. So I'll just go quiet and just let them type their questions.
So another example, was that to me or for the sheriff? Or
Yes, I think that probably is for you, Iver.
oh, well, the government. It seems to me, not to be cheeky, but it seems to me government steps out of its limits regularly. Most governments do. Right. Well, the implications for minorities. Okay. Well, I guess since I'm locked into this position, not entirely by choice, but somehow by choice, I guess I would say that, well, minorities should be considered on the condition that satisfaction of their interests and wishes does not, jeopardize the cohesion of the majority and the political backing which is needed to maintain a stable legal system and a stable society. So minority rights should be somewhat conditional. It's desirable to satisfy them, but not at all costs. I think those would be implications of in practice. I mean, the kind of view I defend would demand that in the end, I think that a simple majority in Parliament would be able to decide on whether the courts perform satisfactorily, and whether the independence granted judges is excessive or overstepped.
Can I come in and just offer, just by way of a suggestion and sort of background, that in Canada, for example, there are judges who adjudicate over the rights of the original native homeland, it's not quite the right expression, homeland rights, and they are generally speaking from the particular group that is that the tribunals relate to. So there are circumstances in which the rights of minorities are expressly recognised by the court structure, and I understand that works really very well in Canada.
Okay, we're just going to wait for some more questions to come in. If we could just type this a little bit faster so we can save on some time here, chaps. I see there's quite a few of you typing. If we can get those questions coming up a little quicker, that would be useful.
Gerald, just while they're typing, can I make an observation in relation to the ethnic minority and minority point made in that last question? There is a fundamental question around the makeup of the judiciary. Certainly in Scotland, I know that there's only 25% of the judiciary are female, and there are very, very few ethnic minority judges. There are, as it happens, our second most senior judge in Scotland is a woman, but they're given the number of female entrants into the into studying law, the output in terms of the number of judges then ultimately appointed looks disproportionate, and it does seem to, on the face of it, look more proportionate in terms of white, middle class, privately educated judges, albeit that is changing. So I think that is something that every every society that has judicial independence has to keep an eye on. I'd like to believe that the Judicial Appointments Board is doing what it can on that front, but I think that is an issue, potentially.
I think that's been raised in one of the earlier debates, and indeed how many judges actually went to either Cambridge or Oxford, which is also very, very high. But I think even in my time in Scotland, the number of females coming through law school has increased dramatically. I think it's now dominated by females opposed to males, if I'm not mistaken.
Well, Gerald, even in my time, and that goes back really quite a long time to the 80s, the majority, it was a slim majority, but it was about 51% of my year in first year were female. And it is now sitting at around 75 to 80%. But one of the issues for female lawyers, and this is probably a slight tangent, is that there is the pay difference that there is between female and male solicitors in practice is very poor indeed. And the Law Society commissioned research a few years ago and showed that a female lawyer was earning about 54% of what the equivalent male lawyer would be earning.
Could I ask if these efforts to increase the share of women judges, is that set by law?
There's no quota, and the Judicial Appointments Board have this statutory duty to ensure that they appoint on merit and not on the basis of any gender or ethnicity. And while I might be keen to press the interests of women judges and suggest that we ought to be more representative, in fact, the system works really rather well with that. The problem is more institutional, sort of slightly further down the route of the profession.
Because I would tend to think that a legal system which recognizes the right of Parliament to superimpose some constraints on how the courts are manned and so on could do exactly that, right? Provided that there is a solid support for it. right, in the general public and in Parliament. I guess it would be quite dangerous if the general requirements of competence are loosened, but to try to balance the composition of the profession according to the values which are held by a solid majority in the population as represented in Parliament might be one of the ways in which a strong parliamentary rule could exercise its power over the courts.
But one would have to look at the makeup of the parliaments. I don't have the numbers immediately to hand, but I do know that there's an underrepresentation of women and ethnic minorities certainly in the Westminster government. There's a couple of additional questions here, Gerald. I'm not really very sure how long we have, given that it's gone 6 o'clock.
It has now. Unfortunately, we started late, but obviously it's depending on how much time you two chaps have as well. If we go for another 10 minutes or so, would that be all right with with both of you? I see. Sorry.
I have a question to the moderator. Am I allowed to break character?
Yeah, I mean, absolutely. The whole idea of these debates is to get the students thinking, because there are clearly arguments on both sides here, as you both demonstrated this evening. However, I know that Jennifer's asked a question a wee while ago. I wonder if we could just go straight to that so we can address the question of Sheriff Craig.
I see there's one question here, but I can't answer it unless I'm allowed to break character and speak my mind. Yes.
Yeah. No. Absolutely.
Right. So you first, Sheriff, or?
Oh well, thank you. I'll just be brief. The question, Jennifer's question, to how can the judiciary remain independent and liable and accountable? There is a process for challenging the competence of judges, and it is a system of independent tribunals, which allows the tribunal to assess whether or not the judge is fit for their service and fit for their duties, and that system works, as I understand it, works reasonably well. And I understand there's been one person who ultimately was removed from office in Scotland as a result of their question of their competencies. So there is a system for that, but that system is, just as the appointment system is independent of the government, and is operated as a sort of full judicial inquiry by not just judges, but by lay persons and qualified lawyers. And the person against whom the allegation of or lacking fitness for office is made is entitled to full representation as well.
I'm not sure, Sheriff Craig, if you can answer the question with regards to the incompetence in Alabama. That maybe is a bit out with your area.
I'm afraid I can't. I don't know enough about the subject to have a view, but I would imagine that there must be some system for disciplining the judges, just as we have. I don't call it disciplining, but it is in effect a form of discipline. Can I also just make a shout out for my other role, which is the half-time role? I teach the judges. So I'm the Deputy Director of the Judicial Institute, and the Judicial Institute is the training body for the judiciary in Scotland from all levels, from the top down. And so we provide a significant amount of training and support for judges in order to improve their skills, but also to keep them up to date, both in terms of legal developments, but also in terms of movement in sort of social mores. We have, for example, a course coming up soon on the effect of adverse childhood experiences on the brain of young persons. And so we have this specific role to educate judges and hopefully undo any concerns that there might be, and I'm not saying that there are concerns, but undo any concerns that there might be about any bias or prejudice that they may have.
Iver, see, there's a question there for you, and it's to do with Poland. And of course, as you know, Dorota was very keen for you to join this debate, who is off as a Polish judge.
I guess thank you so much. I'd really love to answer with a few comments, and then if Sheriff Craig could take the last one, that's interesting about Count Tankula, the YouTuber. But Poland. I mean, I guess what I tried to do was to construct a relatively sensible as I could manage version of the position that seems to be defended by the current regime in Poland. Right now, in addition to claiming parliamentary sovereignty and also the right to rather abruptly make use of simple majority decisions in parliament to change laws, and to give these recent legal changes an elevated standard when they conflict with older laws. The regime in Poland is doing all kinds of nasty trickery, right? So it's they don't follow their own laws. They combine, the nastiest forms of persecution and defamation and abuse of other institutions over which the government has some influence, like public broadcasters and social media and so on. So Poland is in a deep legal crisis, and the independence of the judiciary is at breaking point. There's a massive opposition to the legal reforms which deprive the judges of their independence, but this resistance is very close to breaking. We're within, just maybe days or weeks of the government assuming full control over the Supreme Court, using a manipulated constitutional court to break away from the Istanbul Convention, maybe even, incredibly enough, on the 15th of July, to declare that Polish courts are not obliged to follow the Court of Justice rulings of the Union, which will be an unprecedented situation for the European Union as a whole, and with the limited means the Union has of enforcing compliance with the Court of Justice, this is a threat to the entire legal system in the European Union, and especially considering that there are numerous other governments or legislatives or would-be legislative majorities who tinker with similar abuses of law. So it's an extremely troublesome situation. Brexit was unfortunate. It was an amputation that nobody wanted, but it was a clean and well, the discourse in Britain, I guess, can be discussed, the quality of that, but the popular discourse into newspapers and so on. But the relations with the EU were severed and re-established in an orderly fashion. That's not what's going on in Europe now, with Poland and Hungary and riding on its coattails, Romania, Bulgaria, Slovenia. So it's a very, very disturbing and dangerous situation for the European Union. That's my point of view. So I'm very much engaged in it and very concerned. So if you study law, please keep yourself updated. ruleoflaw.pl is a great site, and also, of course, Verfassungsblog, where most of the material is in English. Okay.
Sheriff Craig, do you want to add anything with regards to Poland, or you still wish to stay clear of that?
It's a troubling area. It absolutely is, and it just goes to show what can go wrong if you allow the politicians to interfere too much. So I'd have thought that the Polish example is a very it's probably the paradigm example for why judges should be independent of the state.
Another question there from Pablo: should the rule of majority be subject to the rule of law? Does either of you wish to comment on that? Because you both touched on it as an interesting sort of question. If either of you wish to comment on that.
By the rule of the majority, I'm assuming that Pablo is meaning in relation to the will of Parliament having elected MPs or MSPs who then carry out the law. So the law comes from, or new laws at least, come from the Parliament, from the legislature, and so they will be enacting laws based on the majority view, whatever that may be. And judicial independence is influenced by it not at all. What judges do is take that law and then apply it to the cases before them.
There's also a question there from Joe with regards to the international resolutions of various organisations. I know we could be touching a little bit on Brexit here, but wondering again if either of you wish to comment on international law versus domestic law and how the two are sort of intertwined.
Gerald, can I just make an observation? Not so much about, I can't be political, as you'll understand, but if I've spent the last hour telling you anything, it's that I can't hold a political view. But there are a number of international treaties, including the Bangalore Principles, for example, which require that courts and judges be independent and impartial. So that is an international convention. It's not strictly a convention, but it's a principle that I would point to as being a useful and helpful one to ensure that judges behave properly.
Right, I can be political as much as I want. I guess that's where this argument that I forced myself to make somehow, it was difficult, really has a disturbing edge to me. Both the European Union and even more so the Council of Europe regime and the UN regime is a very unpleasant mix of law and politics. It's law without an effective executive to carry out rulings. So it's sort of a voluntary law, right? Which, to me, I mean, it makes law and these, classical liberal democratic conception of law that I end up defending here, even though I shouldn't have, is well, it's unavoidably political, and that's a big problem for the ones best equipped to fight for it, like the sheriff here and the other professionals, judges most of all, because it can we can improve respect for this conception of law and improve its execution, even though we don't establish, a properly federal system in Europe or a global federal system. But we really have, but it's a political fight, right? And it's a huge problem, it seems to me, for instance, with the European Court of Human Rights, that, well, it works sort of, right? Some states respect the rulings, some pay lip service to it and pay some fines and keep huge systemic violations of the norms going. So they act like states who, like rich people who find it very convenient to break the parking rules in the middle of city, and then they have to pay a fine of £10 or whatever every fortnight, and that's a very cheap price to pay for having all the other cars away and free parking space for a price they can easily afford. Right? And that's sort of how that system works, and it has an undermining effect on on other international systems as well when it works like that. So yeah, okay, I drifted a little bit. I'm sorry.
I think we're going to have some difficulty answering Andre's question to do with this account angular, because I think it'd be unfair to comment on a specific case. But that being said, I think the question is the judiciary questioning laws in place. I suspect what Andre's perhaps suggesting is where laws conflict. Now, I think that's what we were sort of touching on before, international laws conflicting perhaps with domestic laws and that sort of thing. And more of an overview, would either of you wish to comment on that rather than commenting on something specific, which I think would be inappropriate here?
But
Gerald, I couldn't comment on the particular case for two reasons. I wouldn't comment on a specific case anyway. I don't actually know much about the case other than just some vague information. But really what this is looking at is thinking around when judges are applying the law. There are rules around statutory interpretation and precedent, which means that judges have to interpret the legislation in a particular way. So if a judge happens to, for example, as perhaps the question is suggesting, have applied the law in a way that's contrary to the intention of Parliament, it is likely that the lawyers in the case would lodge an appeal, and a higher court would, of course, provide a clearer picture. So the law around causing distress, generally speaking, and again, not getting to the specifics of this particular case, but generally speaking, is an objective test, not whether it caused fear and alarm for the particular individuals concerned, but whether a reasonable person might consider that it causes reasonable fear and alarm. So I imagine that's what would have happened in that case. And a judge, if they felt that objectively there wasn't fear and alarm, then a person would be found not guilty. And one tiny point, Andrew, it's not the government that has the authority to arrest individuals. That authority sits with the Police Service of Scotland, and they are set up as a statutory body, which of course is set up by Parliament. But it's not the government who instruct police officers to arrest people.
Iver, do you want to make a comment on the checks and balances to which Sheriff Craig perhaps is referring to, which might answer that question, I think, better than talking about an individual case?
On the Scottish Count Dankula case?
Well, checks and balances in general, I think is really what I'm trying to get to, because obviously there's the appeal process in the higher courts, which should maybe address any irregularities in the lower courts.
Well, I'm all for checks and balances, but I'm not.
I think what I'm trying to get to is the safeguarding. So where one has taken a view that there is still an opportunity to safeguard or interpret more fully different rules and regulations.
Yes, I'm not quite sure if I get where you're getting at, but I guess I mean, in general, I guess all legal systems work in the way that there are different things there: the lawgiver, the judge, and the executioner of a judgment, and they all interpret the law from different points of view, and there's a feedback loop going through this whole system, right, where they somehow modify and balance interpretations, and then of course there are more specific checks and balance mechanisms as in the US, but that's kind of I'm not so that comfortable, or I don't know the technicalities of it so well. So when it works, it's good. If it doesn't work so well, I guess I'm brought up in a more consensus-based system. So So sometimes, at least when I look superficially at the American system of checks and balances, it seems to be sometimes to be imbalances weighed by other imbalances, and then you can get in trouble. And of course, the political choice of Supreme Court judges, for instance, is a case where, well, that doesn't seem to me ideal.
Well, thank you both very much. The questions have come to an end, and I know we're well over time. So can I thank you both very much for the time given to address the students this evening. Students, can I remind you to log on tomorrow to see what your position is going to be, whether it is for or against the motion, and when your debates are going to be in around about 2 weeks' time. And again, can I apologize for the technical difficulties earlier this evening? I've been assured by IT it will not happen again, but unfortunately it was a Microsoft update that came in at an extremely unfortunate time, which caused one of the servers to go down. So thank you both very much for coming along this evening and for answering the questions of the students. Chat, thank you very much. This has been recorded and you can watch it, and the link will be put on the forum for you tomorrow. Thank you very much.
Thank you so much. Pleasure to be with you. Bye-bye.
Bye, everyone. Thank you.
Yeah, good night.